Okay. Hello, welcome to EPG Pathshala, course Legal Literacy. I'm one of your course teachers, Maruk Aidenwala, a lawyer. In this module, we are going to look at the Code of Civil Procedure. We are going to look at the different stages that a civil case goes through from the time of its filing to its judgment. The Civil Procedure Code was framed in 1908. It lays down the procedure to be followed by the civil courts while handling a civil case. A civil case is one where the wrongdoer is asked to perform what he has wrongfully failed to do, whereas in a criminal case, the offender is punished. Though the Civil Procedure Code was enacted in 1908, it has gone through several amendments. Provisions have been inserted, provisions have been deleted, provisions have been substituted. Legal notice. The legal notice is the first step taken prior to filing a civil case. Who sends a legal notice? A legal notice is sent by an aggrieved party, a person who is aggrieved by the wrongdoer. The wrongdoer was supposed to do something which he has failed to do, or has done something which he should not have done. A legal notice may be sent by the aggrieved party himself or by a lawyer representing the aggrieved party. The wrongdoer is required to satisfy the demands made by the aggrieved party in the legal notice. If the wrongdoer fails to do so, the aggrieved party may pull him to court. The essentials of a legal notice. Please picture a letter in your mind. The first essential is it should be in writing. Second, it should be in a letter form. It should of course contain the name, address, or maybe even the designation of the sender. Because in certain cases, a person may be sending a notice in his official capacity. The next is the name, designation and address of the party to whom it is sent, namely the wrongdoer. Every legal notice must be dated. It must also contain detailed facts denoting the injury caused by the alleged wrongdoer. For example, the wrongdoer was given a loan which he was supposed to repay on a particular day. The wrongdoer has failed to repay the loan. All these details should be mentioned in the legal notice. Also, the details and particulars of the check by which the loan was given, how the wrongdoer refused to repay the loan, despite repeated reminders by the aggrieved party. A legal notice will also include the steps which the wrongdoer should take to rectify the wrong done. For example, repay the loan. Sometimes the wrong done may be such that the wrongdoer cannot redo it. In such case, the wrongdoer will have to compensate the aggrieved party for the loss caused due to his action or non-action. The legal notice also should contain a period within which the wrongdoer should set right the wrong. For example, repay the loan along with interest within the next 15 days. These 15 days will run from the date the wrongdoer has received the notice. Of course, the same will apply with regards to compensation demanded from the wrongdoer. He will have to pay it prior to that particular date. The notice should also have a paragraph stating that if the wrongdoer fails to meet with the demands of the aggrieved party or only partially fulfills them, he will have to face legal consequences in court because the aggrieved party will file a civil case against him. As earlier mentioned, A legal notice may be sent by the aggrieved party or his lawyer. Depending upon who is sending it, such person should be signing the legal notice. Enclosed to the legal notice should be all the documents and the material which the aggrieved party wants to rely upon. For example, a photocopy of the check given, any reminder letters which have been sent by the aggrieved party to the wrongdoer. Another very important thing is that the person sending the notice must have proof that he has sent the notice and it has been received by the wrongdoer. Hence, the best manner of serving a notice is by hand delivery. The aggrieved party must take acknowledgement of the person receiving the notice along with the date on which it was received. Though a legal notice may also be sent by registered post AD or by courier, as in these two modes of transmission too, there is proof of receipt. The next document we want to talk about is an affidavit. What is an affidavit? An affidavit is a statement in writing made on oath. What is the significance of making a writing on oath? When you make a writing on oath, it means that the maker has promised that what he has said in that document is true. In case of it later being found out that what is stated is an untruth, such maker may be prosecuted for perjury. An affidavit may be used in legal proceedings or for official purpose. For example, in a civil case, a person will put down what he wants to state in writing in an affidavit form, where he says that what he has stated about is the truth. On the basis of that affidavit, the opponent will respond. The opponent will also respond in writing in affidavit form. Hence, the court will come to know what each of the party wants to state with regards to a particular matter. An affidavit may also be called upon by an official authority for official purpose. For example, you have lost your ration card or your passport. Prior to issuing a fresh ration card or passport, the authorities may require you to file an affidavit stating in what circumstances that document was lost and other details of the document. An affidavit for official purpose is to be made on non-judicial stamp paper, which is issued by the state government. Whereas an affidavit for legal proceedings is to be made on court fee stamp paper, or court fee stamps have to be affixed on that affidavit. An affidavit for official purpose is to be made before a notary, whereas an affidavit for judicial proceedings is to be made before an officer of the court. A notary and such officer of the court has the power to take oath. Now let us look at the essentials of an affidavit. An affidavit should be in writing. It should be in paragraph form. Means the affidavit should be divided in paragraphs. An affidavit should start with the name, age, address, and nationality of the maker. An affidavit must be dated because it should be clear that the facts stated in the affidavit are stated so on a particular date, because the facts may subsequently change. It should be signed by the person making it. As earlier mentioned, it may be signed before a notary if it is for an official purpose, or before an officer of the court if it is for judicial purpose. In fact, now affidavits for judicial purpose also may be signed before a notary. At this stage, I would also like to say that certain people object object to taking an oath. An affidavit is generally sworn. They object to take an oath because it is against their conscience or against their religion. In such case, such person may affirm the affidavit. In the last paragraph, it is very important for the deponent to affirm or swear that what he has stated above is true, because the essence of an affidavit is that whatever has been stated therein is the true facts. It's the correct replication of the facts. Now we shall look at the jurisdiction of civil courts. What do we understand by the term jurisdiction? Jurisdiction means the power or authority of the court to entertain a particular type of matter. A civil court has three types of jurisdiction. One, subject matter jurisdiction. This means that a particular court can only handle particular types of civil cases. What sort of cases a court can handle will be laid down under the legislation under which such law is constituted. For example, the Family Courts Act 1984 states that all family matters should be filed before the family court. Hence, a divorce matter, which is a family dispute, will be filed before the family court. The family court has the subject matter jurisdiction to handle divorce cases. The next type of jurisdiction is territorial jurisdiction. A particular court has power only over a particular territory or a particular geographical area. So any dispute which occurs within that geographical area can be handled by a particular court. For example, a family court in Mumbai will handle a family court dispute where the parties reside in Mumbai. Pecuniary or monetary jurisdiction. The jurisdictions of certain courts depends upon the claim made by the party, the quantum of the claim made by the party. For example, under the Consumer Disputes Act 1986, there are 3 consumer forums depending upon the value of the claim made by the consumer. For example, if the value of the claim is up to 20 lakhs, then the district forum has a right to entertain such cases. But where the claim is about 20 lakhs to 1 crore, then such complaint will be filed before the state commission, and where the value exceeds 1 crore, it is the National Commission which will have jurisdiction. There are 2 other types of jurisdiction: court of original jurisdiction and appellate court. A court of original jurisdiction is the court of first instance, the court in which the aggrieved party first files his civil case. So a court of original jurisdiction is the trial court which makes a decision on the matter before it. The appellate court hears appeals from the lower court. The person aggrieved by the order passed by the court of original jurisdiction may prefer an appeal before the appellate court. The appellate court basically listens to the challenge of an order passed by a lower court. Types of civil courts: district court. District courts are the courts of original civil jurisdiction at the district level. Every district must have a district court. The district court is a court, as I said, of original civil jurisdiction, but it will also entertain appeals from subordinate courts. There are 2 courts subordinate to the district court. One, the civil judge senior division and the civil judge junior division. The district court has the power to entertain all types of cases at the district headquarters, whereas the subordinate court, civil judge senior division, has the power to entertain all types of civil cases which fall within its territorial jurisdiction, whereas the civil judge of the junior division's powers are restricted by the value of the claim. It is also important to note that special courts are created under special legislation. For example, industrial courts and industrial tribunals are created under the Industrial Disputes Act 1947 to entertain workers' disputes. Now we are going to look at the different stages which a civil case undergoes under the Civil Procedure Code. First, it is important to know that a civil case is known as a suit. S-U-I-T. The person who files a suit is called the plaintiff, and the person against whom the suit is filed is called the defendant. A suit is filed in a civil court through a plaint. Now, let us look at the essentials of a plaint. A plaint must contain the name of the court in which the suit is filed. It must also contain the name, description and address of the plaintiff as also of the defendant. By description, we mean the age as also the designation, if any, of the plaintiff or defendant. Item number A, B and C together form the title of the plaint. For example, in the family court at Mumbai, Mr. A, the plaintiff versus Mrs. D, the defendant. That is the title of a plaint. If the plaintiff or the defendant is a minor or a person of unsound mind, such averment must be contained in the plaint, and a family, relative or a next of friend should file the plaint on behalf of such minor or person of unsound mind. The plaint should in detail contain the facts constituting the cause of action. What do we understand by the cause of action? Cause of action means the reason for which the plaint has been filed, the reason why the plaintiff has approached the court. For example, if a loan has to be repaid on or before 31st March 2017 and the defendant fails to do so within such period, the cause of action arises on 1st April 2017. The plaintiff cannot file the suit before 1st April 2017 because the defendant may repay the loan on 31st March 2017. Writ of summons. Writ of summons are issued by the court to the defendant. By the writ of summons, the plaintiff is informing the defendant that he has filed a suit. A copy of the plaint is also annexed to the writ of summons. The writ of summons also contains the date on which the defendant should appear before the court. On receipt of the writ of summons, the defendant is to file his written statement. A written statement is a counter or reply of the defendant to the plaintiff and the contentions raised by him in the plaint. The next step is extremely important, which is the framing of issues. The framing of issue stage is when the court reads both the plaint and the defendant. The framing of issue stage is an extremely important stage. The issues are framed by the court. The court reads the plaint and the written statement, and any points which are in variation between the plaintiff and the defendant form a particular issue. There are two types of issues. One, issue of fact. Two, issue of law. To better understand what we mean by issue, for example, the plaintiff has stated that he had loaned the defendant a sum of rupees 1 lakh, which the defendant had promised to return prior to a particular date. The defendant counters it by stating that the plaintiff had gifted him the sum of rupees 1 lakh, and there was no question of him returning it. So the issue which will be framed by the court is whether the plaintiff can prove that the sum of rupees 1 lakh was loaned to the defendant and that he had to repay it before a particular date. At the time of judgment, the court answers every issue which has been framed. Stage of discovery and inspection. At this stage, both the parties exchange photocopies of the documents which they want to rely on, and each party takes inspection or compares their photocopy with the original of the document. Trial. Trial stage is the adjudication of the matter. What do we mean by trial? Trial is the recording of evidence. Both the parties have to produce evidence before their court, evidence which they believe is in their support. There should also be an averment in the plaint that the court has jurisdiction to entertain the suit. Another averment should be that the suit is filed within the period of limitation. What do we understand by limitation? Limitation. Different types of suits have different periods of limitation. That is the period within which the suit should be filed in court. The period of limitation runs from the date on which the cause of action starts. The same also applies in case of an appeal. An appellant should also file his appeal within the period of limitation. The person who prefers an appeal is called an appellant, and the person against whom the appeal is filed is called the respondent. The period of limitation is laid down under statute. For example, a particular statute dealing with a particular dispute will also lay down the period of limitation. It is important to note that the courts have the powers to condone the delay if sufficient cause or sufficient ground is shown. This power can be utilized by the trial court as well as the appellate court. What is sufficient ground? Illness of a plaintiff or an appellant would be a sufficient ground for the court to condone the delay. The relief which the plaintiff claims from the defendant is the last part of the plaint. The relief of the prayers are the orders which the plaintiff requires the court to pass so as to set right the wrong done by the defendant. There are two types of evidence. One is oral evidence. Oral evidence is adduced through witnesses. Witnesses produced by the plaintiff and by the defendant in support of their case. For example, the plaintiff brings in his support plaintiff witness number 1. Plaintiff witness number 1 is examined, that is, his examination in chief is conducted by the lawyer of the plaintiff. After his examination in chief is over, then plaintiff witness number 1 will be cross-examined by the lawyer of the defendant. Cross-examination is extremely important to test the veracity of the witness. After the plaintiff finishes examining all his plaintiff witnesses, then the defendant will bring his witnesses into the witness box. The examination in chief of the defendant witnesses is conducted by the defendant's lawyer, and such witness is cross-examined by the plaintiff's lawyer. Documentary evidence. Witnesses at the time of giving their oral evidence may rely upon certain documents. They may produce these documents before the court. The document is admissible by the court if the maker of the document also comes into the witness box and state that he has made this document. In certain instances, there is no need for the maker of the document to come into the witness box. That is when the maker has died or for some other specified reasons. After the evidence of the plaintiffs and the defendants' witnesses has been recorded, the next stage is the final argument stage. That is when the lawyer of the plaintiff argues his case and the lawyer of the defendant makes forth his arguments. At this stage, I would like to state that the oral evidence of a witness is dictated by the judge to a typist or a stenographer. This typed evidence is called the notes of evidence. So the arguments of the lawyers will be based on the notes of evidence and the documents produced before the court. The lawyers will also rely on precedents, that is, judgments of the higher judiciary which supports his case. After the final arguments are made, the judge will pass his judgment. What do we understand by judgment? The judgment is the reasoning of the court for having passed a particular order. A judgment may be passed immediately on completion of the final arguments, or the judge may adjourn the matter to another date when he will pass his judgment. A judgment has to be dated and it has to be signed by the judge. You must remember that once a judgment is passed, no alterations can be made except arithmetic or clerical mistakes. With regards to any other change, a person has to prefer an appeal to the higher court. Interim proceedings. We all know that a civil case, that is a suit, from the time of its filing to final judgment spreads over several years. But at certain times, the parties may require urgent temporary orders. For such purpose, such party will have to take out an interim proceeding, or what we call an interlocutory proceedings. A judge will pass an order on the interlocutory proceedings, and this order will hold till final disposal of the case. For example, if the plaintiff has filed a suit for non-performance by the defendant regarding his part of the agreement, the plaintiff has paid purchase price for purchase of a flat. The defendant was supposed to hand over possession on a particular day but has been failed to do so. Hence, the plaintiff has filed a suit for specific performance. The plaintiff apprehends that by the time judgment is passed, the defendant may create third-party rights or sell the flat to another person. Hence, he will take out an interim application restraining the defendant from reselling the flat or creating third-party rights. There are two types of interim proceedings: notice of motion or chamber summons. It depends upon the subject matter of the interim proceeding that you will decide whether notice of motion requires to be filed or a chamber summons requires to be filed. I hope I have tried to explain the different steps in a concise manner. For more detailed explanation, please look at the text which has also been uploaded. Thank you.